It's a court of law, court of record, and not a court of public opinion. You're supposed to buttress with an allegation. Now, I had gone to a extent of showing statistics from the Statistical Service, the National Education Authority, as well as the Electoral Commission itself, showing 2 points. Number one, that the voters register has been flawed since time immemorial. Voters register was flawed in its preparation in 1995 in the sense that there was no proof of eligibility. And the product of that proof, the product of that process, which was not with any proof of eligibility, then got carried on onto the exercise in 2012. And 2012 was the first attempt by the Electoral Commission to properly safeguard the sanctity of the voters' register, in the sense that they sought to introduce the proof of eligibility. But rather mysteriously, in the execution of the process itself, the Electoral Commission decided to undermine the law that it had enacted. How did they do so? The Electoral Commission issued a training manual to its officers, in which training manual they indicated or instructed the officers that they shouldn't require any proof of eligibility. So indeed, what the law had required, what the Electoral Commission had stipulated, was required to be undertaken according to law. The Electoral Commission itself, on the ground, in the exercise of the functions itself, authorized its officers to disobey the law. And that opened the floodgate for all manner of persons to register. And for all, so that's exactly the reason why there was an excess of the number of Ghanaians aged 18 and above in the voters register. Because clearly showed that all the persons who were there were ineligible. Some of them were ineligible on account of either being underage, either on account of not being citizens, or either on account of even having registered twice. That's the only situation that could explain how you can have the number of registered voters being more than the number of Ghanaians aged 18 and above, as stated by the Statistical Service. That's why I made the point that indeed the NDC perhaps shot itself in the foot in going to court without any evidence at all. You cannot file an action claiming that there are supposed to be 80 million voters on the register, and then you do not even back it with one statistic. There was no record at all from the Statistical Service. I applied to the Statistical Service for the information. The NDC did not make any application whatsoever. They did not exhibit any application that they had made to the Statistical Service for such information at all. Then they also sought to say that the NIA cards were inadequate, the NIA cards were not sufficient to cater for the process of registration. Clearly, no evidence at all. But I formally applied to Executive Secretary of the NIA for the relevant record, and the record that was given to me showed that as of today, at least 10.5 million Ghanaians aged 18 and above had been issued with NIA cards. And then there were also some figures from Passport Office. So even the two added will bring about 11.5 or 12 million people who can have an ID card, who can utilize an ID card for the purpose of registration. Now, I recognize the fact that it will still lead to a little bit of a shortfall in terms of persons who are expected to be voters register. But the total number of Ghanaians aged 18 and above is 16.6 million. And it's not every Ghanaian aged 18 and above who registered to vote. So, granted that even 40 million Ghanaians will register to vote, it would mean that it will be left with only about 2 million people who would need the guarantor system to register to vote, or who may not have an ID card of a sort to register to vote. And I made the point that the guarantor system has been established to be effective by the Electoral Commission. In the last voter registration exercise in 2019, as well as the one just before, in 2018, about 94 to 95% of the persons there registered with the guarantor system. So really, there's no evidence of any potential disenfranchisement. All such allegations were just unsustained, were unsustainable, they had not been proven, they were just empty allegations that were thrown up in the air.
Your evidence, is it sufficient? And I'm asking that because showed evidence that will result in people who are already on the electoral roll having to go back to register. Should it not be evidence that shows that Godfred, for instance, registered in 2012, but he was not 18 years of age? Is your evidence not speculative more, just like the court said that no census had been carried out recently? The Statistical Service data were projections?
No, but there must be a body in the country which can lawfully undertake such an exercise. The Statistical Service has been clothed with constitutional capacity under Article 186 of the Constitution to carry out such statistics in the country. If you cannot rely on statistics of documents or data from such an entity, then who can you trust? I mean, the institutions of state must be respected and must be expected to act in accordance with their constitutional mandate. So if I have come to court with evidence from constitutionally established bodies, Statistical Service and Electoral Commission and even statutory bodies, the NIA and whatever, and you come to court with your empty hands, just throwing up allegations in the air, who should be believed?
But is that fair to those who are actually 18 and they registered lawfully?
Yeah, but they have the opportunity to vote. I don't seem to understand you. Nobody has been disenfranchised.
Yeah, the point now is that there is COVID, there is the danger of having to go and register, and the point is that through no fault of theirs, in fact, no evidence has been suggested to show, except that we know that at least from what we have from the Statistical Service, you have more people than those who were actually 18, so it's problematic. But in terms of specifics, there are people who are actually 18 who got onto the roll, who now have to risk having infection to go out there and register.
But this was the first time there has been a compilation of register. This was the first time there has been a compilation or recompilation of the voters register. The voters register was initially compiled in 1992, not under the Constitution. And then by virtue of the transitional provisions of the Constitution, when the Constitution was or Constitution entered into force, was accepted as regular. There was another compilation exercise in 1995. And then there was another compilation exercise in 2012. So it is not novel, it is not unusual to have another compilation exercise. But that is one. But I made the point that indeed all opportunities will be made available for every Ghanaian to register to vote. The NIA card, as I indicated, has been issued to over 10.5 million Ghanaians who are aged 18 and above. There is also a reasonable number of Ghanaians, about 2.5 million, who are also aged 18 and above, who are issued a passport. But even if you do not have any of these instruments, you have the guarantor system. The guarantor system that you can avail yourself of to register. In 1992, so the point must also be made that the old voter ID card, there's no magic about it. There's no magic about it in the sense that the very first time there was reference to an old voter ID card as an instrument for identification of a potential registered to vote was in 2012. So in 1995, when the CI-12 was enacted, there was no reliance on an old voter ID card. In 1982, definitely, there was no voter ID card. And indeed, in registration exercises in 2012, 2018, 2019, limited registration exercises, most Ghanaians who applied to register for the first time to vote, they have no old voter ID card. So what is this fuss about an old voter ID card? I think that only the NDC perhaps will be able to tell us the value that they have on, or the value that they place on the old ID card and the reason therefore.
There are those who hold the view that had the changes that we saw happen at the commission by virtue of the removal of some of its leaders, and if that change had not happened, and in fact they make the point that the position that your party held was that you wanted a new register. You said the register was bloated, and so if it had not been the changes that had happened with the president making a new appointment, we may not be having a discussion about a new register entirely. And in simple terms, you succeeded either directly or indirectly to get the commission to agree to what you had held prior to coming into power.
First of all, we're taking me clearly into the realm of speculation. You're also seeking to introduce politics into the work of the Electoral Commission. I think that must be deprecated. That definitely does not hold at all. The Electoral Commission is independent. Whoever occupies the position of chairperson of the Electoral Commission has the necessary discretion and independence to operate. And I think that the Electoral Commission itself, as previously constituted, if I may put it so, clearly on account of what transpired in the Abu Ramadan case, would definitely have carried out a new voter registration exercise, because they themselves told the court that about 56,000, first and foremost, the point must be made. During the Abu Ramadan case, the position of the Electoral Commission was that majority of Ghanaians registered with the NHIS card. Majority of Ghanaians, majority of people over 40 million. That's impliedly the case. Majority of, and then they come to court to produce evidence of those who actually registered the NHIS card, and they come with 56,000 names. So that clearly showed that there were billions of people left on the voter roll who had unlawfully entered on account of having registered with the with the NHIS card. So the Electoral Commission itself, if indeed wanted to be faithful to the Constitution and also wanted to faithfully comply with the orders of the Supreme Court, would have definitely felt the need to compile a new voters register.
But the commission differently constituted didn't agree with the imposition of the MPP in the past. In fact, when it set up a team of experts led by the late VCRC Crab, they recommended that they should not compile a new register.
That doesn't change the point. It actually reinforces my contention that they are totally independent and they have a discretion to exercise at any time. And that's what the Supreme Court has stated today, that where the Electoral Commission has two lawful options available to it, it can elect to choose which one to comply with. So, in 1995, as I indicated to you, the instruments of identification, in fact, there was no identification process at all, but the exercise there was constitutional. And then, in 2012, there was reliance on old voter ID card, was also constitutional. And then, 2020, the Electoral Commission decides that in the spirit of ensuring that the sanctity of the voters register will be upheld, there's a need to eliminate the use of the old voter ID card. And the Supreme Court has held today that is constitutional. So I think that we must be careful in imputing motives to the Electoral Commission the way they conduct their functions. The most important thing is that 3 decisions of the Supreme Court, Abu Ramadan number 1, Abu Ramadan number 2, and the decision today have upheld the independence of the Electoral Commission. So those decisions are very consistent and the Supreme Court perhaps ought to be applauded for maintaining that consistency. It is not a case where they were seeking to depart from Abu Ramadan number 1, Abu Ramadan number 2. They actually were consistent with those rulings, and they refer to them in the orders here.
Finally, on the bit about the CI 126 going forward, is it the requirements we have currently? You have to use the passport, you have to use the Ghana card, and you go by the guarantor. Are they robust enough to ensure that we don't come back to registering again? You made reference to the number of times we've compiled the register. We don't see that with the passport, for instance. They just migrate the data, no matter the form they take. They don't say that we should all come and register for passport again.
Yes. But the point is that is why there was a need for us to eliminate the old voter ID card, if you ask me. Because there's a need for us to undertake a process in accordance with the system that the EC can vouch for. And therefore, if indeed it had been shown that the old system was flawed and defective, why then do you rely on products from the old system? Go ahead, start on a clean slate, a tabula rasa, and then we proceed. So, definitely, there will be some inherent weaknesses in whatever exercise a human being undertakes. But I think that the EC, demonstrably, the NDC itself showed in court that the biometric verification devices that the EC had procured were much stronger than the old system. It was part of the exhibit that was filed by the NDC and attached to their processes in court. And I use it extensively in my argument that indeed if you go by the NDC's sole exhibit that they attached and filed in court, it actually supports the need to compile a new register with a new system. I thought it was going to be some 5-10 minutes.